And gentlemen, I hope you enjoyed the invigorating networking break and had fruitful conversation with your peers. Now let's redirect our focus as we step into the heart of a conference with session 2. The session 2 is challenges in enforcing commercial litigation and arbitration. Get ready for a deep dive into the complexities of enforcing commercial litigation and arbitration. A distinguished panel led by this seasoned moderator, Nofal Abdul Hadi, Senior Project Manager from Saudi Arabia, is geared up to share invaluable insights and experiences that will undoubtedly broaden our understanding of this critical facet of the legal landscape. Without further ado, let me introduce our esteemed panelists for the session 2. We have Robin Moser, who is a partner with Loyens and Loyef Zurich. Akshay Sapre, independent lawyer from India. Dr. Amir Tabara, international arbitrator, academic, and a dispute resolution lawyer, University of Birmingham, UAE. Abdullah Al-Bakr, chairman and CEO, Al-Bakr and Associates, law firm Kuwait. Kareem Mahmood, partner, dispute resolution, Hadaf and Partners, UAE. With this powerhouse of expertise, we are poised for an enlightening and thought-provoking session. Let's welcome our esteemed panelist and moderator as we delve into the challenges of enforcing commercial litigation and arbitration in session 2. Over to you, Nofal.
Ladies and gentlemen, welcome everyone into World Litigation Forum. I am Nofal Abdul Hadi, a PhD researcher and senior project manager in Kingdom of Saudi Arabia. Today we will discuss the subject of challenges in enforcing commercial and litigation and arbitration. We will explore this topic from different 9 angles, including the public policy and stakeholder calibration and notice requirement, and the role of technology as a continuation of the previous session, in addition of the resistance and delay of tactics and asset discovery and recovery, and the choice of forum and applicable law, and the enforcement of arbitral awards and jurisdictional challenges. We are honored to have esteemed and distinguished international guest speaker, and they will share us their thought and experience about this topic. And the first topic that we will start discuss, the jurisdictional challenge. But before we start, I will inform our guest speaker to feel free to answer. I will present the topic and question, and you have a free to answer and share your experience and thought. And in the end of this session, we'll keep time for questions and sharing the knowledge from all attendees. And let us start our journey. We will start with enforcing litigation and arbitration decision across the different jurisdictions. And we'll start with Mr. Abdullah. What is the challenge raised when we enforce the litigation and arbitration across different jurisdictions?
Hello, everybody. Good morning, and thank you for attendance. And it is a pleasure to be here among this 17th edition of the forum. Enforcing arbitral awards for an arbitrator, it is where the laws have knowledge and acceptance of the arbitral award. and the arbitration committee or arbitration center. Because I'm from Kuwait, we have let's say very old-fashioned laws for accepting arbitration awards to be enforced in Kuwait and to be executed also by the ministries. So what the procedures that any arbitration award have to be appealed to the court to have the court approval before that this arbitration award is applicable and aligned with the laws in Kuwait and doesn't have any violation for them. So in this way that this kind of arbitration for this award may be, and sometimes by the decision of the judge itself, he thinks that this award is not enforceable or applicable to be executed in Kuwait. Then this award will lose its power to be enforced also, and to take the rights and claim rights from the defendants. So let's say the first thing is the law itself. It have to be more flexible and be acceptance for the arbitration from any center, from any arbitration committee. We have some issue that we have seen in Kuwait that an arbitration award that have been issued from CAS courts or any sport related body that will affect the sport authorities or entities in Kuwait, like gyms, clubs, football clubs, any entities that have been stopped by the court, demanding that this award was violating the Kuwaiti laws that have been changed too many times, and it will not be enforceable in Kuwait. In that time, the claim that have been rising the arbitration or the arbitrator himself, who is trying to enforce the award, have lost his power. He has only a document that he cannot do anything with. So what he will do, he have to file a case in Kuwait to get this arbitration to be in line with the Kuwaiti laws, and something in the award will change by the decision of the court. This one will be a big difficulty for any, let's say, arbitrator or anyone who have gained this award to enforce it. This is one of the challenges that we see, and we have, let's say, we have seen too many times within the past 3 years, because sport laws in Kuwait have changed too many times to be applicable with the Olympic laws and sport laws. The second thing is who will enforce the arbitration law, because some of the arbitration centers, I have been set as an arbitrator, they have the full potential to demand, or let's say to enforce high penalties, or let's say penalties on the guy who's losing the arbitration award. That is not forcible in Kuwait, let's say, for my jurisdiction, because we have to go by the law and the regulation to how enforce judicial awards or something like that. So you will have some procedures that is not applicable to be done and to enforce this award. These two challenges, I think, is main challenges for me.
Excellent, Mr. Abdullah. Before going to the next question, I saw a lot of people come recently. They was joining other session and they come just now. We will introduce the guest and organization again, and we'll start from Mr. Amir.
Good morning again. Amir Tabbara from Birmingham University. So I'm an assistant professor of law specializing in dispute resolution and arbitration. And yes, and I'm also a lawyer, and I specialize in construction disputes. And it's nice to be with you and with the panelists today. Thank you.
Abdullah Al-Bakr, Chairman and CEO of Al-Bakr Associate Law Firm in Kuwait. Also doing business and working also from Kuwait, Riyadh, and Dubai, and DIFC. I'm a practitioner, assistant practitioner in DIFC and IDGM, and in Qatar Financial Center.
Thank you, Mr. Moderator. Good morning. I am Akshay Sapre. I practice independently in the Supreme Court of India and other high courts, and I do mostly commercial litigation, dispute resolution, and when I'm not in court, I'm editing books for LexisNexis and commentaries. So it's a pleasure to be here and looking forward to a great session with my panelists. Thank you.
Good morning, everyone. My name is Robin Moser. I'm a partner in the Zurich, the Swiss office of the continental European law firm Loyens and Loeff, with offices in the Netherlands, Belgium, Luxembourg, and Switzerland. My area of specialization is dispute resolution, mainly commercial litigation, commercial arbitration, a lot of enforcement work, and to a certain extent, in particular in asset recovery matters, also white-collar crime.
Good morning, everyone. My name is Kareem Mahmoud. I'm a U.S. qualified lawyer. I've been in the UAE for the past 10 years with a firm called Hadif & Partners. We have offices in Abu Dhabi and Dubai. We're about a 100-lawyer outfit. I specialize in dispute resolution, so litigation, arbitration, and a growing white-collar practice.
Thank you for... Yes, thank you for our guest speaker. Yes, Mr. Abdullah, one more question about the jurisdictional challenge. How do conflict of law and varying law system impact the enforcement process?
If I may, I can, let's say, give an example. It will be more clear what are the jurisdictions challenges that we have. Since, let's say, 2022, the rising of third-party investments in the region from funds everywhere from the world coming to the GCC, we had seen so many opportunities, let's say in my specialty in sectors, the fintech and technology, that too many opportunities, too many entrepreneurs and startups are trying to raise funds. So they start in one jurisdiction, like let's say from my country, from Kuwait, they apply the Kuwaiti laws to their agreements with their angel investor, let's say, the first round. The second round, they will go to another territory, let's say for UAE, DFC, ADGM, and then they will apply free zone laws or Dubai laws or Abu Dhabi laws. Then when the third round comes, they will go to the market, to the IPO, let's say, in Saudi, in Nubu market, or in Nasdaq. So we have 3 jurisdictions, or maybe 4 jurisdictions based on their investment round. Each one of the investors going to an agreement with a different jurisdiction. When there's an IPO, let's say the last level of investment or the public investment, which applicable law that will be done? It's the one with the IPO, where the IPO is placed. Then we will have too many issues with the old investors. They want to exit, how they will exit, what are the return of investment that they have been agreed for, if there's a mismanagement in the company. Everybody will go to a different court based on his jurisdiction. I have seen that last year with one of our clients who have been had mismanagement and his company have lost too many profit. Then many of investors have been filing cases, one in Saudi, one in the DFC, and one the first round in Kuwait. So we have 3 awards have been issued against this company for mismanagement, but with 3 different countries. Which one is the applicable one? How you can enforce it? So it was the let's say mistake from the in-house lawyer. To be honest, he didn't revise all the contracts. He didn't unify the jurisdiction for all of them, and just he was, let's say, going with the startup with the founders to gain the funds, because this is what they are focusing on to have their operation going. So when this matter have been came, we have seen what are, and I was on the investor side, what are the best award that have been issued against this company. I tried to take it was the Saudi rule also. So I have taken to enforce it in Kuwait. But the most of the award was in favor for different investors of different rights and different claims than our investor. But this is what I can bring to see, so to the matter, as an example. Then I went to Hadif, also with Umar Al-Hulub, your partner there. So I tried to figure out which is the best applicable way to enforce the judgment, the Saudi judgment in the IFC. So you have too many jurisdictional challenges that you have to unify it before going in agreement. This is one of the things. The second thing that the country courts, if they doesn't acknowledge and let's say another GCC award or jurisdiction to be enforced in the GCC itself, and the Kuwait, let's say, on here will find challenges, especially when until now Kuwait doesn't recognize the IFC and ADGM as commercial entities, or the arbitration that is issued in the arbitration center to be they have the right to be enforced in Kuwait. So in some way we will have this issue. It's happening in Kuwait, let's say, and the GCC countries, that free zones will not be the awards that have been issued from the free zone arbitration centers not being forced in the domestic courts and domestic, let's say, ministries. This.
Excellent, Mr. Abdullah. Thanks for sharing us this practical experience from the market and from the field. And we will go to the enforcing arbitral awards can be complex, especially when we faced with resistance from losing parties and navigating the international enforcement regimes. Mr. Robin, Mr. Karim, he can share us some challenges that enforcing the arbitral awards and navigating international enforcement regimes.
Well, there are a couple of challenges when it comes to the enforcement of awards. I mean, first of all, if you have an arbitral award, you would likely want to enforce that award at the seat, at the domicile of your opponent. If that's in a jurisdiction that ranks relatively low on the corruption index, for example, then that might be a bit challenging. So what you would need to do is finding assets in an enforcement-friendly jurisdiction. One additional challenge is, of course, finding the assets. We will get back to that a bit later. Once you have found the assets and you need to enforce the award abroad, cross-border, then you can, in all likelihood, do that based on the New York Convention on the Enforcement of Arbitral Awards, which has about 160 signatories and provides for, in general, relatively easy cross-border enforcement. Challenges there come to a certain extent with the formal and the material requirements of the convention, formal requirements. So you would need to present to the enforcement court either the original or certified true copy of the agreement to arbitrate, as well as of the award. Some courts, some jurisdictions there are a bit less formalistic than others. In Switzerland, for example, it is sufficient if you provide simple copies. In other jurisdictions, you would need to have notarized and apostilled copies of those documents. Then also some challenges come with the material requirements of the New York Convention. In particular, you will need to demonstrate that service of process has occurred and was proper, that the right to be heard has been respected, and that the award is enforceable. Again, the New York Convention provides some basic standards here, but those are applied differently in certain jurisdictions. Some have a higher threshold than others.
Thanks, Robin. I'll speak to some of the considerations here in the UAE, since that's where I practice. First and foremost, in terms of setting client expectations, the first issues we have to overcome are really procedural, in that we need a power of attorney in order to submit any case here in the UAE. And given that a lot of our clients are abroad, sometimes that may mean weeks of attestation, legalization. So I just set that out because, by the time the clients obtained an arbitration award, they're very eager to enforce. They spent a lot of money and they want to just find some assets and recover. So sometimes that comes as a surprise. In addition, yes, the UAE is a signatory to the New York Convention, but procedurally the courts look for this certificate of finality before you file when enforcing an arbitration award. So that's something that you won't necessarily find in the law, but it's a checkbox exercise that you need to complete. And depending on the arbitration center that you're using, they may have familiarity with it or not. So it's just something that might take a few more emails, a few more phone calls, and then some discussions with the arbitration center to find the right wording that would then translate into Arabic and work to complete that exercise. The other thing that we come across quite often is we will be contacted towards the end of that process where the arbitration is completed, the request for relief. Basically, we've provided no input on the request for relief without considering what that looks like once it's translated into Arabic and how local execution courts, or enforcement courts rather, would implement it. So just by way of example, we had a situation recently where I believe it was a Swiss arbitration, and the arbitrator found that a director was wrongly appointed, and he confirmed that the director is wrongly appointed, and that had a big impact on the control of the company here in the UAE. But what the award didn't say was the prior director should be reinstated. Right, so if you go all the way towards the end of that process, it's really important to have worked with local counsel to, help improve the request for relief so that you can implement the actual award once you get it.
Excellent. طيب, what do you think, Mr. Kareem, about how do the national court contribute to enforcement of arbitral awards, and what difficulties may be raised in obtaining effective remeits? Remeits, yeah.
I think the prior example is a good example of that, and knowing what the parameters of the court would be and working within them. So going back to the prior example, we've had to supplement enforcement proceedings with additional proceedings in the UAE to try to enhance that award, to get a different court, basically a court of first instance, to go the extra step in awarding that relief. So just knowing what the procedures are and also what the capacity of the individual courts in the region. Abdullah mentioned the many different parallel courts that exist, and also the ever-changing nature of, a lot of the laws are changing here in the region. So you have to keep abreast of what the latest is.
Yeah. Yeah, it's certainly challenging to navigate the international enforcement regimes. As mentioned, some jurisdictions are a bit more recognition and enforcement friendly than others. Certainly go-to jurisdictions when it comes to enforcement are, in my experience, the UK, the US, also Singapore. Europe is quite enforcement friendly as well. My firm covers Europe, and we have set up a network of enforcement specialists, so we do a lot of coordination also of enforcement cases within continental Europe, so a relatively good overview there. Easy to enforce our awards, certainly in Belgium, the Netherlands, Luxembourg, France, Switzerland. A bit more challenging is it, not from a legal standpoint, but more from a factual standpoint, or for other circumstances. Germany and Austria in particular, because the court fees there are extremely high. In Germany, you would need to pay a percentage of the value of the award to enforce the award, and if that's a high amount, then also the court fees will be extremely high. Same holds true to a certain extent for Austria. We had very positive experience. We discussed that in the break before. Is the DIFC courts in Dubai, quite effective and also enforcement friendly. You also ask what are the effective remedies when it comes to an enforcement. I mean, first of all, what you want to achieve is getting an attachment or a freezing order. That already helps to put a lot of pressure on your opponent and to secure the assets into which you want to enforce. Most jurisdictions grant you a freezing order that has national effects. Some jurisdictions, in particular common law jurisdictions, also order freezing order that are intended to apply worldwide. Those are very effective means, and also in common law jurisdictions, in certain of them, you can get a disclosure order against the opponent that obliges the opponent to disclose its worldwide assets, which is certainly helpful if you want to enforce an award also in other jurisdictions.
Thanks, Mr. Robin. In continuation of challenges, the selection of appropriate forms and litigation and arbitration, it's determined the applicable law can be significantly impact the enforcement process. Can you share us what the challenge exists in selecting the appropriate form or for litigation or arbitration, and how does affect the enforcement?
Sure, I think that decision is usually taken at the phase of contract negotiations. So before a dispute actually arises, and the first question, if you're drafting a contract, will likely be, do you want to go for litigation or arbitration? You have the two options. There are certain advantages and disadvantages. Certainly depends on your standpoint and against what do you compare it. Then, I mean, the decision usually depends on the bargaining powers of the parties that negotiate the contract. If you have a strong party against a weak party, then the forum is the seat of the stronger party. If you have parties with equal bargaining power, then what you often see is that they either go for litigation or arbitration in a neutral forum, so that they're trying to find a compromise. Popular neutral forums are, well, in continental Europe, certainly Switzerland, also France, London, Singapore, in relation to Latin America, certainly also the United States. What you need to consider always if you're actually planning for a dispute is where is your opponent located, and does the jurisdiction which you select have an enforcement treaty with the jurisdiction of your opponent, because that makes the enforcement much easier.
Excellent. But better to be decided in early stage and mentioned early stage to avoid any conflict later on. Yes. Excellent. Okay, about the next angle or next perspective, asset discovery and recovery, identifying allocated asset for enforcement purpose, particularly in the case of involving non-compliant parties or hidden asset, can be during donating the task. We will ask our guest speaker to share their thought about the challenge are faced in identifying the allocating asset for the enforcement purpose, especially in the case of involving non-compliant parties or hidden asset. Mr. Karim and Abdullah, they can share us their thoughts.
Well, obviously, there's no problem collecting on assets ever. I think that it changes from jurisdiction to jurisdiction, but generally, you're worried about procedure and what's at the end of the tunnel. For us, there's a benefit to doing a little bit of work on the front end so that you can know in the first instance whether it's worthwhile to go down the route of potentially very expensive proceedings. Robin mentioned he had some success through the DIFC court, the UAE. There's parallel jurisdictions here. So you can go through the local Arabic court's enforcement process, and depending on a number of factors, you might consider going through the DIFC, which is a common law court. There's some different implications and costs there to consider. And even if there are no assets in the DIFC, you may still want to consider utilizing that process. So, yeah, I mean, there's a lot of challenges here in terms of dissipation of assets, in terms of trying to avoid enforcement, appealing, muddying the waters, challenging the authenticity of documents. There's a lot of tricks up people's sleeves to avoid enforcement, and I think I was talking with Robin about this earlier, is identifying strategic paths forward early on helps cut down the time significantly, especially if you're able to identify assets and then proactively maybe have a freezing order, precautionary attachment, or just consider what the likely next steps are. Now, recently we've had some success with ineffective disposition claims, which for this market we haven't seen that successful too often. And what typically happens if you have a judgment debtor who will do anything at all costs to avoid enforcement, they'll transfer assets. In a common law jurisdiction, once you're notified of proceedings, it's quite difficult to start moving assets around to avoid enforcement. Whereas here, you have up until the date of judgment, really, or that used to be the cutoff. We've got some competing judgments now in the onshore courts where we've reversed some transactions on the basis that the judgment debtor was aware that they would likely be owing these amounts to the creditor. So, it's a constant cat and mouse, and I think the work that you put into it at the outset can help limit the time required and perhaps lead to an opportunity for an early settlement.
Yes.
I think you summarized it all, cat and mouse. It's like a chess. I will give also an example. In Saudi now, I think before 2 months, there have been changes in the regulation of execution of awards, that I can go to the execution court and seek discovery of assets for the defendant or the guys I'm facing the court, so to see whether this case will be applicable to execute after having the award or not. This is one example that the changes in the laws that will have effectiveness on the court system itself or judicial system itself. But I'm going back to Kuwait. In Kuwait, we have, if you have an asset in Kuwait, and most of the Kuwaitis' asset is a house that have been given from the government, but you cannot block it or you cannot seize it. Also, you cannot sell it because there's a law that if you have one house, only one house, it will not be enforceable to execute or to sell if you have one house. So that means most of the Kuwaitis are millionaires, have 2 houses and more, so you have to find the other house for him that it will not be registered on his name. And most of the youth have only one house by the government. So discovery of the asset is the most important thing. The challenge is that for recovering these assets, it depends on the jurisdiction itself, okay? But discovering, let's say in Kuwait, we have to file a case, and this case have to be just trying to appoint an expert to find what asset that he have. This case will take in minimum 2 years, just to finish. 2 years, then, like Mr. Mahmoud said, he will transfer all the assets to anybody, to his sons, and you can't enforce the execution if you get it, or the award when you get it on his sons or his wife. It's a dependent personality and financial personality. So when we have the award, we cannot execute it or recover the asset. But I know it's there. I know he has a farm, he has car, he has a boat, he has a house, and I can't do anything. And recently, the government, when declaring 2021, declaring the Bankruptcy Act in Kuwait, they have cancelled the civil arrest orders. We had, I think Kuwait, it was the only country in the GCC that have applying this term, that the civil arrest order. I think in UAE it's also enforced, yes, sorry. So you only have the ban travel. This is our travel ban for the one that is have been issued the award against him. So recovering the asset, when you know it, it is difficult for us in Kuwait to enforce it, but I cannot say it's impossible to do it. It's difficult. The most difficult things to do is to detect the asset. Where is it? And to find it and to have it an official paper that we have this asset. But like Mr. Mahmoud said, we cannot. You have to file a case again to cancel the transfer if it was done upon filing the case or upon the hearing of the case. So there's some challenges there, but you can discover by a case in Kuwait, but in Saudi is a different matter. This is the challenges that you when discovering and recovering assets.
Yeah, I can only agree to that. I mean, the biggest challenge, I think, in any jurisdiction is finding the assets. That also certainly holds true with regard to Switzerland, which is known to have quite high secrecy standards. I mean, statistically, I think it's about 20% of the worldwide private wealth is held with Swiss banks. Swiss banks have quite high secrecy standards, so it's extremely difficult to find the bank accounts. We also don't have any registered from which you can see who holds participations in companies. Financial reports do not need to be filed and published, so secrecy standards are quite high, which makes enforcement, in particular identifying the assets, extremely challenging. What can you do to find the assets? I mean, one of the most important tools is certainly open source intelligence. So whatever you find on the web can be helpful, and you will sometimes be surprised what people put out in the internet. Also, social media. Then there are certain registers that you may want to check in, and that holds true for various jurisdictions. Certainly the commercial register may contain some valuable information. Real estate registers are available and to be checked. There are IP registers, plane registers, car registers, you name it. Then certainly helpful is in appropriate cases is hiring an investigator, so specialists that help you with locating the assets, and also quite effective in certain jurisdictions is filing parallel criminal proceedings, because then the criminal authorities do the asset tracing and the asset locating for you. Also quite effective if you're looking at strategies and tools to identify assets is go abroad. There are several jurisdictions which provide very helpful tools. One of them is the United States with the so-called 7082 statute or possibility that allows you to take evidence in the United States in aid of foreign proceedings. What has proven to be quite helpful in that context, and what you can do with the aid of these proceedings, all US dollar payments worldwide are basically settled via 4 or 5 major banks in the United States. And with the appropriate orders, you can get disclosure of all worldwide US dollar payments that go from one bank account to the other. And if you are looking for bank accounts or assets to attach, that's extremely helpful. In the UK, you have similar tools. I think not as far-reaching, but still, the Norwich Pharmacal order or the disclosure orders that are quite helpful. And also in the DIFC, to my experience, you can get worldwide freezing order and disclosure orders that oblige your opponent to disclose the assets.
You can the third party disclosure and also the clawback from third parties as well. If funds were committed to, professional services, being able to claw that back is something that's possible through the DIFC. I just wanted to add quickly to your point on you'd be surprised what people put out there on social media or on the internet. I had a situation recently where we were going after a judgment debtor, and it was difficult to find anything, but his wife had a penchant for interior design and remodeled the entire house and then put it in a magazine. So we were able to identify which house it was from Google Maps and the makeup of the pool furniture and the design, and there might have been a picture of the cars without things blurred out. So it was, you never know. It's worth doing the Google searches, so.
Thanks for sharing us the strategy and tool that we use for effective asset discovery and recovery. We'll go to the next point with Mr. Akshi, resistance and delay tactics. The parties often employ tactics to resist or delay the enforcement of litigation and arbitration decisions. So what is the tactics do parties commonly employ to resist or delay the enforcement of litigation and arbitration decisions?
Thank you. Well, one thing is certain, that there's no challenge in speaking about challenges to arbitration enforcement, because there are just so many. And I come from India, and I think the legal system is such that the parties, the parties really don't have to think much. The procedure itself is so lengthy at times that the trial becomes the punishment for the parties to enforce the award. So that's why I started that there's no challenge. Yeah, there's no challenge in speaking about challenges, because there are just so many. The problem arises is that the arbitration goes very smoothly, because it's a private tribunal constituted either by the court or by consent of parties. So you have expert people on the panel. The real challenge is for the unfortunately successful claimant who has an award in his or her or its favor, and now has to present it before the court of the first instance to enforce it, or to see the color of money. It will take years, maybe at times, for that other party to actually comply with the award. That is maybe because of the procedure. So the intention to arbitrate, as we have that principle of intention to arbitrate, the problem is that the intention ends with the arbitration. There's no intention to enforce, because the unsuccessful party will have umpteen number of provisions to put that award into certain legal complications that the color of money will never be seen. One of the problems that these parties face in enforcing is that it has to go before a district court, which is the court of first instance. Now, those courts may or may not be well equipped to handle that kind of arbitration, or handle those kinds of awards where they would understand the complexities of the commercial transactions which the parties had, the dispute arose, the award has been in my favor or in favor of whichever the claimant, and there is some commercial sense in awarding a particular set of damages to that claimant, which has to be enforced in a time-bound manner. Otherwise, the person loses interest, monetary interest. The person loses interest in actually enforcing the award. So the challenge begins after you are successful and not in being successful in the arbitration. Now, there can be multiple number of challenges. One is that the arbitrators were incapacitated in performing the functions as arbitration. Now, this ground is taken at the enforcement stage, that the arbitrators could not have rendered this award, when this ground has already been maybe adjudicated by a competent court where the award was challenged. But still, that ground is available for taking it. Now, for something there is already a judgment in my favor, an enforcement court cannot go back into it and delay those proceedings. But one possible solution which the courts in India have devised, the High Courts, Supreme Court also, where if there is a monetary award, where I am supposed to receive some payment under the award, that payment has to be deposited in court upfront. Otherwise, there will be some kind of a coercive action. Now, that coercive action can be attachment of property, can be any kind of civil liability fastened upon you. But if I am supposed to receive 100 million under the award, the court will direct the party to deposit that amount in court. So at least you have secured that amount and the award cannot be then frustrated. The problem in this arises when the other party is a government party. Now, a government entity will have so many other privileges which a private contracting party may not have. They can have state immunity, they can have sovereign immunity. They can say that I will not pay this amount because I am not running away. I am a government. I am not going to run away. So I am not supposed to deposit this amount in court. This amount is to secure the award, but that is not the intention. The other intention is speedy recovery of that amount under the award. So whether you are government, whether you are the private citizen, once the amount goes out of your pocket, comes into the court, then it is easier for the court to at least enforce that award. So it's not up to the government to say that I am not running away with this amount, this can be paid at any time. So this is the time when the enforcement is filed. This is the time to actually pay up. So in my opinion, the system itself has to be developed in a way that the enforcement becomes as smooth as the award, the passing of the award itself. Because bulk of the work is already done. One now doesn't need to apply its mind whether that award is right or wrong. That also is done. So whether the amount has to be paid under that or not should be a matter of procedure and not matter of proceeding. So these are my 2 cents on it. Thank you.
Actually, a comprehensive explanation for the tactics. Okay, about the strategies can be employed to counterattack this tactics and ensure the timely, effective enforcement. Mr. Kareem, can you share us some strategies can be employed to counterattack this tactics and to ensure timely, effective enforcement?
Sure. I mean, timely enforcement is a relative term, so I think setting client expectations is my first approach, and ensuring that there's an alignment on how long it will take, what the likely challenges are, because you can't account for all the potential challenges. Sometimes you get things out of left field, so to speak. So I like to identify early on what the likely challenges will be, and offer some potential solutions, such as a precautionary attachment early on in the proceedings, so that at least you have, especially in this jurisdiction where on enforcement, if you're challenging an enforcement, you're not obligated to put the amount. So what ends up happening is an incentive to drag on the execution as long as possible. So in that scenario, having a freezing order in the UAE we refer to as a precautionary attachment, is something that's a very helpful tool, and something that we look at in the first instance. Other than that, I mean, there's a number of things, but mainly setting client expectations, getting a lot of the procedural work done in terms of the POA, as I mentioned before, having all the certifications, having those expectations in place will help move things along. And yeah, that's, I think, a good first step.
Thanks. Mr. Robin, you have any add point for this?
Yeah, maybe when you look at certain concrete examples of delaying tactics commonly employed. I mean, what you see quite often is non-participation in proceedings, evasion of service, of documents. What you can do there is make sure that the opponent gets everything, that it is properly served, if need be, by way of legal assistance, so that you have a record of service and can prove that that everything was done properly in the enforcement phase. What you also see, or what I see quite often in enforcement proceedings, is that the opponent constantly changes lawyers in an attempt to delay the proceedings, because then the new lawyers ask for an extension of the timeline because they need time to prepare. Quite helpful is talking to the court, making them aware that this is a commonly applied strategy, that opponent also applies that strategy potentially in other jurisdictions. What you see as well is unjustified requests, for example, for security for costs, or challenges to jurisdiction. There you have no other option than just to fight them off. Same holds true for third-party intervention. So if third parties interfere or intervene in the enforcement process and claim that particular assets are actually not held by your opponent but by them. Strategies to counteract, I think what's quite helpful in my experience is freeze whatever you can. Because if you freeze all the assets of the opponent, then the room to maneuver is quite limited. They will have difficulties engaging lawyers, paying the lawyers. Also consider increasing the pressure against the opponent. So try to enforce in various jurisdictions, not only in one jurisdiction, to increase your chances of recovery and to keep them busy and to drive up the costs for them for continued resistance. There are also other options, such as litigation PR. So if you put out a newspaper article, describing certain practices of your opponent that might be detrimental to their business, but also to engaging lawyers. And in some jurisdictions, you can also resort to criminal law means, evasion of enforcement, or hiding and dissipating assets, maybe a criminal act. You have the options to file avoidance actions, and in certain jurisdictions, you can even resort to to the tools that the insolvency law provides. For example, in Switzerland, hiding or dissipating assets is a ground for, or maybe a ground for, immediate opening of bankruptcy proceedings against your opponent. To my knowledge, you can also in the UK get a receivership order over an opponent if that person constantly tries to evade or to prevent enforcement in bad faith.
Thanks, Mr. Robin. Thanks. We will come to Dr. Tabara about notice requirement. Notice requirement and multi-tiers arbitration clause. Are they any enforceable that in context of UA?
Yes, thank you for this question. Actually, this is a recurrent problem that happen in most of the arbitration here in the UAE, especially when we talk about construction dispute, because generally speaking, most of the generally speaking, construction clauses provide for notice requirement for the contractor to observe before filing a claim. So in general, this type of clause provide that if the contractor considers that he is or she is entitled to an extension of time or to additional costs, for instance, they should serve a notice within a time frame. Otherwise, they would be time barred from making such claim. And there is a lot of literature, especially here in the UAE, whether these clauses are enforceable or not. And I have seen in many arbitration that a lot of submission are made on whether the contractor would be entitled to make a claim or not, which for me, I always talk about effectiveness of arbitration and celerity of arbitration, and I think that this type of arguments would delay the arbitration proceedings. The thing is that we don't have a clear position whether these notice requirements are enforceable, especially under UAE law. And we can see that there is some divergent approach. For instance, civil law jurisdiction tend to take a one-by-one approach in regard to the enforceability of such clauses, whereas, for instance, common law jurisdiction enforce notice requirements. So also from the party's perspective, it would be a good idea when also choosing the arbitration panel to see how is their position regarding notice requirements, especially for the contractor, for instance, who didn't serve this notice within the time frame. Regarding multi-tier dispute resolution clauses, so these are clauses which provide for escalating dispute resolution mechanism. So for instance, the first thing that the disputed party should do, they should, for instance, ask the engineer, for instance, to make the determination, then the dispute adjudication board, then they need to go to mediation, and if they fail to settle this dispute, then they go to arbitration. So when we talk about multi-tier dispute resolution clauses, we talk about precondition for arbitration. So it's also a good idea for the parties to know what is the position of the UAE law regarding this type of clauses, whether they are enforceable or not. So contrary to notice requirement clauses, as I have mentioned, there are some ambiguity whether they are enforceable or not. Multi-tier arbitration clauses enforceability are more clear, especially under UAE law. And we have some decision from the Court of Cassation of the UAE annulling an arbitration award because the parties have not following the escalating dispute resolution clauses. So it would be a good idea for the parties and for the arbitrator in order to immune the arbitration award from any action to set aside, to respect this notice requirement, the multi-tier dispute resolution, and to escalate the dispute according to the applicable clause. So these are recurrent matter and maybe basic matter, but they are always here, and this type of question always raised in the context of construction arbitration. And according to my point of view, a lot of submission are sometimes made which delays the proceedings, and it can be somehow considered as part of the tactics that parties might use in order to delay also the arbitration proceedings.
Thank you, Dr. Tabara, for this comprehensive explanation. We'll go to the next point as a continuation of the first session, the role of technology. Mr. Abdullah, he can share us some thought about the role of technology, about advancement technology such as blockchain, AI, and online dispute resolution have a potential to address a challenge in enforcement, litigation, and arbitration. How can the technology advancement like blockchain and artificial intelligence, online dispute, enforcing the litigation and arbitration?
Maybe I will continue a discussion outside that we are talking with the doctor and with you, Naufal. When you have an intelligent machine that can summarize and specify every, let's say, component that you need in a case, in a contract, and that can lessen the time that you need to have, let's say, some dispute figured out, or what is the best way to handle it. It will be very effectiveness to your role as a lawyer, and then how you will execute any award that will be coming. I like to give examples. I will go back in time to 20 years before. Okay, we had in Kuwait archiving system. It's named Salah Al Jassim. He's a guy who had made an archiving system for case management. It was very simple system that you have to upload everything, and the only thing that it will give it to you, a reminder of the date that you have put it in the system for a case, for a hearing, for execution procedure that you have to do. After that, so many case management programs or systems have been coming to the area. We have tried. I'm just trying to remember more than 20 systems to figure out which is the best system that you can use to enforce, or to know what is the best way to enforce judgments in the best way, the commercial or arbitration judgments. Most of the case management systems have, let's say, they have missed the judgments that has been issued by cassation courts in Kuwait or any countries. The old system that I'm talking about, the one for 20 years, have that potential, or have that point that he can give you by adding the tags, what you need from the wording, what are the time frame for the verdict itself, or the award from cassation courts from Kuwait and Egypt, and he can give you an example how to have an award to execute, or what happened in a similar case. The many systems that are coming to the region now, what I'm seeing, was just focusing on the archiving, or just focusing on giving you tools to manage the case, but doesn't give you tools to know which awards have been issued in other countries, how to execute them, how to have the good procedures to execute them. So what we have done, we've been going back to Google in my firm. We went back to Google and we sat with Google in UAE and told them that we have data of 6 tera of cassation awards from Kuwait, Egypt, UAE, and Qatar, and Saudi, from the commercial court only in Saudi. We need to put them in a system that will be beneficial for all of lawyers in Kuwait and on the region, to have access to manage their cases, also to have knowledge about what other courts in the GCC are issuing in similar cases that we have. We have done a system with them. It's implemented now for 3 years in our firm. That with Google, with the evaluation of Google services and AI coming to the surface, also to the scene, they have implemented now AI in our system. Now we can just give it one word. If I just want to say arbitration UAE, or 2 words, let's say, he will give me none less than 200,000 award that can be enforceable in UAE, because they have using this knowledge, this idea, this information, and how to put a system that can think for you in the easiest way to enforce this arbitration. And this is done. We have spent 3 years in development with Google itself, and placing it in our firm, and try to release it to the region for I think next year they will release it in the region. So this is one kind of example that you can use for AI. Second thing, that what we was talking about, from 2015 we started consultancy and advisory for our clients, and then until 2018 we had 2020, before Corona, we had more than 4,000 contracts draft that we can use for any client. But from 2020 to 2022, we have 4,000 contracts using AI. and it's developing every day. There's one of the other examples that how we use AI in drafting contracts and comparing contracts, that we don't need to focus on the technical part. We are choosing to be only legal part, not technical part. Most of the lawyers are going on the technical part, putting their mindset on the terms that in the agreement, and it will take decisions, meetings, negotiation with the other party on behalf of our client. I don't want to do this part. I need just to focus on the legal terms that is aligning with the law, aligning with the concept of the deal itself, and I will give it to the client as an advice or as a consultancy. This affected our time frame to submit and to deliver the contracts to our clients. We have managed to finalize contracts within 2 hours. Most of the maximum time is 4 days for finalizing a contract and giving advice. It didn't affect the quality of the consultancy itself. It added more personnel to our firm. We have doubled the size of the lawyers, doubled the size of the consultants in our firm. This is what we have been using the technology in this part. And that helped also in figuring out what is the best, what are the terms that is being used in the fintech and technology sector also, what are the procedures that is being done when developing an application, developing a platform, or even a system, SaaS model, BaaS model. You can name the terminologies that is there. Being a lawyer going in that sector, it gives us an easy access to that world that is a little bit, let's say, away from us as a lawyers. Blockchain, it will give you, as for now, let's say in Kuwait, we are developing with one of our clients an eKYC system for all individuals in Kuwait. So I can use it, I can access this system as a lawyer, any commercial or non-commercial entity working, they can access this system, and they can gain the information about who our client, or the other side, or the other party, and hopefully in the future we can figure out what asset that he have by using this system. It will when it be implemented with banks. So every part of technology it have its good side and bad side, but we're trying to take the optimistic, let's say, hope that there's a good use of this technology for our benefit as a lawyers.
Okay, Mr. Abdullah, I will stay with you at the same point. It is really, we are glad to hear, after using the artificial intelligence and technology, the number of contracts jump and increase recently. Can you share us what's the potential benefit and the risk associated with using technology in enforcement process?
Yeah, I have a good example. I've been hacked before. I've been hacked. I paid $200,000 for the hacker. This is one of the risks that if you don't put a good security system, and for that we had to been working with Google to enforce a security system and frames to protect our clients' data also, and our data. Sometimes you can't figure out where will you be hacked. From your printer, sometimes from your flash memory somebody is bringing to the firm, or just somebody went to a website, have been sending a Trojan or a virus in your computers and will affect all your network. This is what I'm talking about, an external hacking, but there's also an internal hacking. Somebody will disclose any information that he will see it is beneficial for him to sell it outside, to gain some bribery or something like that. It's happened everywhere, and law firms are not away from this risk. Another risk that we will have, that you will be, first of all, swimming along in the sea. Most of the clients that is used to all traditional firms will not go to a firm that is using technology in that way, in this extensive way, and giving him his data. I have been sitting with too many clients, entities, individuals. They're refusing to work with us because I'm afraid that my data will be on the internet. I cannot give him 100% security that this thing will not happen. Every major company in the world have been hacked, their data have been stolen, but you have to take all the necessity, let's say, security measures or cyber security measures. I have been the cyber security forum here in Dubai before, and I had heard one of the governmental personnel that is talking about how to protect the patient files in the hospitals and to be enforced by a law. So I take that idea, I went to our government and tell them that we need also some, let's say, minimum layers of security to be enforced, not only for the hospitals, law firms, any data that any client will put it in anywhere, it will be essential for his wealth, for his social information, anything like that. So this risk is always there.